Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, hope you're all well. Welcome to the latest episode of Talking Business. So what we're going to be talking about this month? Well, I've got a couple of cases for you. I've got a review of the new failure to prevent fraud offence, which is now in force, and then a quick update on the London Stock Exchange's new PISCES platform for trading shares in private companies. So first off, let's look at those cases. So the first one was all about some warranty claims, and the High Court held that the sellers of a company were liable to the buyer for damages for breach of warranty after the Education and Skills Funding Agency found that the target company had overclaimed funding due to breaches of the agency's funding rules, and that resulted in a clawback. So it gives us some useful insights, this case, about notifying warranty claims and also the measure of damages that you can get for breach of warranty. So the facts then. The buyer had acquired the entire issued share capital of a company whose business was focused on education and training for young people. And that was significantly funded by the Education and Skills Funding Agency. The purchase price was based on a maintainable EBITDA of about £2.5 million and a multiplier of 5.5. So within a year of the acquisition, an audit by the agency revealed that the company had overclaimed more than £1.2 million in funding for the previous academic year as a result of breaches of the agency's funding regulations. So that resulted in the agency clawing back funding of about £780,000 from the target company. Now, the sellers initially paid this back to the buyer under an indemnity clause in the sale agreement. But then, even though they'd done that, the sellers then asked for it to be returned because they said that actually the claim under the indemnity was time barred. But the buyer brought a warranty claim against the sellers, alleging that because of the funding breaches, the company's true value was actually substantially less than the buyer had paid for it. So when the case came before the court, there were various different issues that had to be considered. And the first one related to just service of the warranty claim notice. So the agreement said that a notice of warranty claim had to be notified by a specific date, and that any related legal proceedings then had to be both issued and served by the 14th of February 2023. Happy Valentine's Day. In fact, the relevant claim form was hand delivered to the sellers on 14th of February. So the court held that service by a specified date meant on or before that date. And so it included service on the actual date specified. And then in addition, the court said that the reference to served meant served in accordance with the requirements of the civil procedure rules. And so what that meant was that it was satisfied by hand delivery of the claim form to the seller's addresses. And it did not require the proceedings to be brought to the actual attention of the sellers, which was what they had argued for. So the next issue related to the contents of that warranty claim notice. So here, the sale agreement required the notice of warranty claim to include details of the nature of the claim, the facts and circumstances giving rise to it. Now, the sellers said, well, that means that each warranty under which the buyer was claiming has to be specifically identified in the warranty claim notice. But the judge rejected that argument, finding that there was nothing in the language of that relevant provision that required any warranty to actually be identified by number in the notice of claim. The next issue that the court looked at was the measure of damages. Now, here, the court confirmed that the damages for breach of warranty, as is normal, would be based on the difference between what we call the warranty true value. So in this case, they said that's the price paid by the buyer, and then the warranty false value. So that's the actual value of the company taking into account the breach of warranty. So taking into account the fact that the warranty was false because there'd been a breach. So, in accordance with the method originally used by the parties, the appropriate valuation was a multiple based approach using the company's maintainable EBITDA and an appropriate multiplier. Now, in this case, the judge reduced the company's maintainable EBITDA by the clawback amount and then applied a lower multiplier, just 5 times, not 5.5 times, which the judge said reflected the risks that would have been perceived by hypothetical negotiating parties who were aware of the breaches of warranty. So, because of that, because we'd reduced by the clawback amount of £780,000 and then applied that multiplier, that meant that the total damages, taking into account all the different things, were actually over £5 million, which was obviously substantially more than the original clawback amount of £780,000 that had been recovered under the indemnity. Then finally, the court considered the type of claim that the buyer was bringing, that the fact that there was that indemnity claim and the fact that there was a warranty claim as well. And as I say, the funding overpayment was covered by a specific indemnity in the sale agreement. And like I say, the buyer had in fact made a claim against the sellers under that indemnity for the clawback amount. But the agreement also stated that the buyer couldn't recover more than once in respect of the same facts or circumstances. And the sellers said, well, that means that the buyer can't now bring a warranty claim arising out of the same matter, the funding clawback, because it had already had that indemnity claim. But the judge again rejected that argument from the sellers, saying that actually that relevant provision prevented double recovery. So you can't recover more than once, but it doesn't prevent a double claim. So the buyer effectively had to elect between recovery under the indemnity and recovery under the warranties. And entirely unsurprisingly, it chose the higher damages award. So what lessons can we learn here? Well, one thing I would say from practice is it is surprising how often buyers serve a warranty claim notice right at the contractual deadline. Now, there may be very good practical reasons for that in terms of investigating the claim and not being fully ready to actually bring the claim. But it is helpful to know that when a clause refers to service by a particular date, that includes the date itself. But what I would say is that the buyer could have avoided that particular argument if it had just served its notice a few days earlier, and then there would have been no question about that timing. I think it's also useful here to see the court's approach to calculating damages and its acknowledgement that warranty breaches can impact things that are quantitative earnings, so things like maintainable EBITDA, but then also qualitative aspects of valuation, so things like reputation, risk profile, and those things then justify adjusting the valuation multiplier that is applied to those quantitative earnings. Okay, so that's that one about warranty claims. So the next case saw director payments being scrutinised, so payments to directors. And here, the High Court found that various payments that had been made by a company to its former directors were either transactions at an undervalue or preferences. The payments purportedly had been made to repay directors' loans or payment of management fees. And it's an interesting one, I think, because it highlights the risk to directors where payments made to them by their company are not properly documented and the company subsequently becomes insolvent. And I'm sure we're all aware of the fact that actually, particularly in small owner managed businesses, maybe those kind of transactions aren't always documented quite to the level that we would like. So let's have a little bit of a quick refresher on what I'm talking about when I say transactions at an undervalue and preferences. So these are both types of reviewable transaction under the Insolvency Act. So what that means is they are transactions that can be set aside once a company is in liquidation or administration. So the court can set aside a transaction as a transaction at an undervalue if a company makes a gift or it enters into a transaction for significantly less consideration than it provides. So effectively, it's giving away value, if you like. And in that case, the transaction must also have been entered into during the 2 years before the company became insolvent. Now, a company can have given a preference to a creditor if it does anything which, if the company does go into insolvent liquidation, results in that creditor being in a better position than they would otherwise have been. And the company may have been influenced by a desire to prefer the relevant person, and the preference must have been given during the 6 months before the onset of insolvency, or within 2 years if the creditor was connected with the company. So that's what we're talking about when I say transactions at an undervalue or preferences. So in this case, there was a company that had been used as a vehicle to purchase a property and then develop it into 2 flats. The project was financed by a bank loan and also by personal loans from the company's directors. Now, there were delays in completing the property development, and that meant that the company had to take out additional bridging finance in order to refinance the bank loan. The development was finally completed in September 2018 when the second flat was sold. And then in April 2019, the company entered into creditors' voluntary liquidation. So the liquidator's claims in this case were assigned to a litigation financing company, which is not uncommon at all. And that company then brought claims against the directors in relation to 2 key transactions that had taken place within 2 years of the liquidation. So first of all, almost £350,000 had been paid to the directors in May 2017, and that was done to repay part of the original directors' loans. So that payment was funded from the surplus left after the original bank loan had been refinanced. And then almost £160,000 was paid to the directors between September 2018 and February 2019. And these payments were made from the proceeds of sale of the second flat, and they were used to repay the balance of those original directors' loans and also to pay something that was characterised as management fees. So the claimant said that each of these was either a transaction at an undervalue or a preference under the Insolvency Act. The directors, they disputed that the company was insolvent at the time of the transactions, and they also claimed that actually they were legitimate repayments of sums that were owed to them by the company. None of the relevant agreements that we're talking about here between the directors and the company, so either the loans or the management fees, none of that was properly documented. So when it came before the court, first of all, the court looked at that payment in May 2017. And here the court found in favour of the directors, holding that it was neither a transaction at an undervalue nor an unlawful preference. So despite the fact that the arrangements weren't formally recorded, the directors had managed to credibly demonstrate to the court that their loan to the company had been made on the same short-term basis as that original bank loan and that it fell due for payment within a year. So that meant that the 2017 payment had been made to repay sums that were properly due to the directors. Now, critically, the company was not found to be insolvent at this time. So the fact that their loan to the company was on similar terms to previous projects also really helped the directors to rebut the presumption of a desire to prefer themselves over other creditors. So that wasn't their primary motive. They'd made the loan available on the same terms as previously, and it had just fallen due for repayment. That was the argument and the finding. But in contrast, those payments that were made between 2018 and 2019, they were largely found to be transactions at an undervalue or preferences. So remember, some of them have been characterized as management fees or management costs, and they were held to be transactions at an undervalue because there was no record of any agreement requiring the company to pay them. The court viewed these basically as retrospective attempts to justify the withdrawals when the company was facing insolvency. And in relation to the payments that were made in that period that were characterized as repayments of outstanding directors' loans, well, the court found that these had been made to the directors in their capacity as creditors of the company, and therefore they amounted to preferences because the company was already insolvent when they were made, or it became so as a result of the payments. And again, there was no evidence to rebut the presumption that there was a desire to prefer the directors. So it's an interesting case. There's no new law here, I would say, but I think the decision does highlight the importance of having clear, robust documentation for all financial arrangements between directors and their companies. Like I say, I am well aware that it is not uncommon for those kind of arrangements, maybe in small owner managed businesses, to not be fully documented. But if you have undocumented director loans or remuneration agreements, such as management fees, then I think they are going to be highly susceptible to challenge by a liquidator if the company does subsequently enter insolvency. And even if directors genuinely believe that they're entitled to these payments, that lack of formal records, including things like explanatory board minutes, makes it very difficult, I think, to defend against claims that they are transactions at an undervalue or indeed preferences. So, typical lawyer's mantra, but get it in writing. Now, I mentioned that the new failure to prevent fraud offence has come into force. So, this is a new offence that's been brought in under ECTA, the Economic Crime and Corporate Transparency Act. It marks, I think, quite a significant development in UK corporate criminal liability. It's got pretty wide-reaching implications for large organisations, their advisors, their clients. So let's have a bit of a recap on what that offence is. So it applies to large organisations if an associate, so that could be an employee, an agent, or a subsidiary, commits a specified fraud offence intending to benefit the organisation or its clients, and the organisation doesn't have reasonable fraud prevention procedures in place. Now, I said that it only applies to large organisations, so that is an organisation that meets at least two of these criteria. So either more than 250 employees, more than £36 million of turnover, and more than £18 million in total assets. So that's employees, turnover, assets. You've got to meet two of those three tests there. When we're talking about what do we mean by a specified fraud offence, well, there's basically a list of all the relevant fraud offences set out in a schedule to ECTA, and that includes things like offences under the Fraud Act, the Theft Act, and also fraudulent trading under the Companies Act. So it's a strict liability offence. So what that means is it's not necessary to prove that senior management at the company knew about the fraud, but it will be a defence for an organisation to show that it had reasonable procedures in place to prevent fraud. So that is the main defence that organisations will need in order to rebut the allegation of the offence having been committed. Now, the Serious Fraud Office and the Crown Prosecution Service have recently published some updated joint guidance for prosecutors on the approach to corporate offending, which includes this new offence. So it's worth a look at some of the sort of key points from that guidance, I think. So, firstly, the guidance says that prosecutors are expected to make active use of the new strict liability offence. It clarifies that prosecution of corporate entities is a vital part of enforcing criminal law and deterring economic crime. So it's all very well having these offences on the statute book, but prosecutors are being actively encouraged to look at bringing these claims. The guidance also confirms that ECTA reformed the law of corporate criminal attribution for quite a wide range of economic offences. So liability can be attributed to a corporate entity either through the statutory failure to prevent offences or, where they don't apply, through the common law identification doctrine. And the new offence removes the need to prove involvement of the directing mind and will of the company. So that was a bit of a stumbling block historically for prosecutors in bringing these kind of offences, that they had to show, like I say, that the directing mind and will of the company was involved. Well, you don't have to do that anymore. They don't have to show that. So, as I mentioned, and the guidance again highlights this, the organisations can defend themselves by demonstrating that they had reasonable procedures in place to prevent fraud. And the guidance refers to 6 flexible outcome focused principles for implementing those procedures. There's some separate government guidance in relation to those, which it's really worth having a look at. And then finally, the prosecution guidance confirms that the offence applies to large organisations wherever they're formed or incorporated, provided that the fraud involves a link to the UK. So international companies could be caught if one of the underlying fraud acts took place in the UK, or even if it's just that the gain or loss occurred in the UK. So, like I say, I think this new offence makes it significantly easier to prosecute organisations for fraud. And the focus is very much now on prevention, not just detection. So even if the offence technically applies only to large organisations, I think the principles in the guidance do represent good practice for all businesses who would be well advised to review and update their fraud prevention policies and procedures, ensuring they're tailored to the specific risks that they face and that they are communicated properly throughout the business. Okay, finally, last one this month. I just thought it was worth a quick update on PISCES, because the FCA has approved the London Stock Exchange as the first operator of a PISCES platform. Perhaps no surprise that the LSE was the first out of the blocks there, but it's good to see that we have now got that first approval. And then at the same time, the stock exchange has confirmed that PISCES platform is going to be called its new private securities market. And it's also published a consultation on the draft rules for that market. So what do I mean by PISCES? Well, it's another very cleverly developed acronym which stands for Private Intermittent Securities and Capital Exchange System. PISCES. So that's a new regulatory framework that allows specified investors to intermittently buy and sell existing shares in private companies. It's intended to increase the liquidity of shares of participating companies, giving investors easier access to growth companies, and also offering additional opportunities for investors, which includes the people like employee shareholders, to realise their investments in those companies. So it's being developed using a financial markets infrastructure sandbox, and the FCA has published rules for the sandbox. It did that in June of this year. And like I say, eligible firms can apply to the FCA to operate a trading platform within that PISCES sandbox. Now, although it's the FCA's rules that set out a sort of overall framework for the operation of a PISCES platform, much of the actual detail is then left to the operator's discretion, meaning that basically the specific rules that apply to participating companies are going to vary between individual PISCES platforms. So depending which particular operator's platform you decide to join. So like I say, the LSE, London Stock Exchange, first organisation to be approved to operate a PISCES platform, and that's going to be known as the PSM, another acronym, the Private Securities Market. So ahead of the launch of that PSM later in 2025, the stock exchange has published its draft rules for consultation. These rules, they're the rules that will apply to companies seeking to join that new market. So what's in the rules? Well, in particular, kind of a headline point is some specifications around eligibility. So to join the London Stock Exchange's private securities market, companies will need to satisfy certain eligibility criteria, including meeting at least two of the following requirements. So you have to have conducted a debt or equity fundraise of at least £10 million. That included a material participation of experienced independent investors within the last 3 years. You have to have total assets of at least £20 million based on your last audited financial statements. And you have to have annual turnover of at least £10 million, again, based on last audited financial statements. So you've got to meet two of those three. So a recent debt or equity fundraise of at least 10 million, total assets 20 million, annual turnover 10 million. So it's private companies that are within that space. Then some of the other points picked up in the draft rules. There's going to be a requirement for shareholder approval. So a company will need approval to join the new private securities market by ordinary resolution of its shareholders. It might also need actually to amend its constitution to ensure compliance with the PSM rules and to dematerialise its shares to allow for electronic settlement. Then there's some rules around trading of shares. So trading is going to take place through intermittent auction events using the stock exchange's existing system. So there is going to be a new type of an intermediary that's going to be called a registered auction agent. And that agent will consider the eligibility of investors to use the private securities market and place trades on their behalf. So companies will need to decide whether to hold open or permissioned auctions and how frequently they're going to hold them. So when we're talking about a permissioned auction, that allows companies to exclude certain investors from selling or buying their shares. An open auction obviously allows everybody. And then finally, there are some rules on disclosures. So before each auction, a company will need to make certain financial and other information available on a new disclosure portal. So in terms of mandatory disclosures, those will be limited to those that are prescribed by the FCA, but companies could choose to make additional disclosures if they wanted. So that, like I say, that was the LSE publishing its draft rules for consultation. That consultation period is now ended, and we are hoping that the new private securities market will be open for business before the end of 2025. And we are all waiting to see how many companies are going to sign up to it and how successful it will actually be in practice in promoting that liquidity in the shares of certain private companies. So one for us to keep an eye on, and I'm sure we'll be revisiting that on the podcast in a future episode. That's it then for this month. Hope that was useful, and I will see you next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.